Everybody. I'd like to welcome everyone to this afternoon's SARIPA webinar. It's been a while since SARIPA have run our webinars, but we are off and in the starting blocks for today's session. I'm going to introduce my panel in a few minutes. Firstly, I want to thank SARIPA. I want to thank Worksmans, my firm being the sponsors for today's webinar. Just by way of introduction, my name is Eric Levenstein. I am the head of the Insolvency Business Rescue Practice Group at my firm at Worksmans, and I will be moderating today's discussion. And my role, obviously, is to try and get as much as I can out of my speakers and out of our participants on the topic, and let's see how we do. There will certainly be an opportunity towards the end of the session. We should complete it at around about 1:30. So from 1 o'clock or just before, please post questions on the Q&A in the Zoom facility, and we will try and answer as many questions as we can towards the end of the session. Today's session is a discussion about the role of stakeholders in the South African business rescue environment, pressure points, and effective intervention. And we thought that we would identify a range of stakeholders who all have a say, and let's say a role to play in business rescue. We are now 13 years down the line since the legislation was introduced. We've discussed it at all sorts of forums, the Business Rescue Summit for one in September last year, and of course at our end of year conference in KZN towards the back end of last year. And I think here we sit on the 15th of April, all sorts of international pressures on South Africa, local pressures in the economy that is still, I think, to an extent struggling. There's certainly economic and financial strain across various sectors and industries. And I think the importance of discussing corporate rescue intervention remains highly relevant. And it's not something that should be put on the back burner, particularly by an organization like SARIPA. We have discussed various aspects of the role of stakeholders. For example, SIPSI had a very interesting session late last year and earlier this year, a webinar on the issue of business rescue, with the Department of Trade and Industry taking a major interest in where business rescue is as we head into 2025. So the business rescue case proposition, I think we all accept, is that business rescue remains a highly relevant tool for restructuring. Of course, the role of informal restructuring is there. It can be done, holding the hands of the company in distress to try and get the company back on the road. But of course, there's no moratorium or stay on claims in that environment. So business rescue, of course, is the statutory shutdown of claims by way of the official moratorium. And it is really, for me, certainly, and we'll hear from our panelists in a minute, certainly a practical, progressive, and value-preserving alternative to liquidation. It was designed to allow distressed but viable companies the breathing room to restructure, preserve jobs, renegotiate prejudicial contracts, and of course, importantly, compromise historical debt and provide the company with a fresh start to continue to trade into the future. Just from a statistical perspective, in 2024, over 1,000 companies went into liquidation, while only 230 entered business rescue. So for me, the discrepancy speaks volumes. It suggests that something in the system might not be working. Either directors aren't acting early enough, or the support structures around business rescue are not functioning as they should. And I think the role of stakeholders, all of us on today's webinar, all have a role to play, whether you're a business rescue practitioner, an auctioneer, a banker, a lawyer, of course, liquidators as well, all have a role to play in driving the narrative and the case for business rescue going forward. So who are these stakeholders? I listed a whole lot, but really I'll run through them quickly. The general public and the media, organizations like SARIPA, of course, the business rescue practitioners, our new Insolvency Court, all of those in the legal fraternity. I think our universities and educational institutions have a major role to play. Organizations like the Institute of Directors, SAICA, the trade unions, SARS, of course, the banks, PCF providers. It's our distressed funders that are looking at providing PCF and distressed funding into companies that are in trouble, the competition authorities, Department of Mineral Resources and Energy, and of course, SIPSI. I think it's about driving the narrative for rescue, and the question is whether or not these role players are playing the correct role insofar as we see it in promoting the case for business rescue. So I think it was Mahatma Gandhi that said, the future depends on what you do today. And for all of us involved, stakeholders in business rescue, I think it's literally time to take the bull by the horns, work and collaborate together to move the business case for business rescue forward, so that in 10 years from now, we can look back and continue to be able to say that we're relying on an important restructuring tool being business rescue. I'm going to then introduce my panel. I'm very lucky, and they can all come on video now. Very lucky to have an esteemed panel of experts in the field. We're joined by a senior representative from SIPSI, members of the business rescue and restructuring profession, representative from the banking sector, and each brings a unique lens to the topic. And we certainly look forward to an open, practical, and let's say energized session today. So we've got Ian Fleming, co-founder and CEO of Engage Business Turnaround. Ian, you can wave to say hello so everyone knows who you are. Thank you. Gideon Stubbert. Is Gideon there? I don't see him. Gideon?
I'm here, Eric.
Are you there? Sorry, you're on my other
That's not on
screen.
your screen. Yeah.
Sorry. Director
Thanks.
of Corporate Business Rescue Advisory. We've got Joe Mitchell-Murray, Director at Deloitte Africa Turnaround and Restructuring. We've got Vianney Nkola from SIPSI, Senior Manager at SIPSI. Really welcome him. And of course, Harry Filippo. I think most people know Harry, Group Head of Recoveries at Investec Limited. So let's kick off. And I'm going to start with the role of, let's say, the general public and media. Do they have a role to play in driving the business rescue narrative? Now, I remember sitting, Joe, at your launch of a Deloitte restructuring survey quite a few years ago. And I always remember Anthony Evans Anthony from APSA, saying to the audience that the best way to improve the narrative around BR was to talk about the success stories in business rescue. Talk about the good outcomes, compare business rescue payouts to liquidation dividends, talk about speed of process, effectiveness, the skill set of the BRPs, opportunity to make maybe good distressed M&A transactions, and the various other good news stories around business rescue. So I think the important takeaway for everybody is what constitutes a successful business rescue. I think a successful business rescue means different things to different stakeholders. You know, is the media always going to focus on fees? Are they going to focus on good outcomes? Are they going to focus on SOEs? Do they talk enough about what the business rescue practitioners are doing to contribute to the South African economy? So I'm going to go around the room. I'm going to actually start with Joe, and then I'm going to ask others to comment just on the role that the media and let's say the opinion of let's say public opinion, what that role has to play in rescue. Joe?
Thanks, Eric, and good afternoon, everybody. I certainly agree the media has a role to play, but I perhaps wonder whether public perception is also key to promoting business rescue. And for me, public perception, I suppose that's through experience. So today's creditor in a business rescue is potentially tomorrow's director facing a similar situation where their business is facing financial distress, and the ability to consider business rescue, as we always want, early enough, really driven by their experience in similar matters. So, for example, an efficient process, a transparent process, a fair process doesn't necessarily mean that they get all of their money back from a business rescue, but have they had a positive experience with the process? Because that might encourage more business rescues as we move forward. I think it speaks to that universal challenge that everybody faces. It's not just us here in South Africa, that early intervention is key to get those good outcomes. And so the more that, for me, directors are educated about business rescue and, as I say, get the experience of a positive outcome, that starts to build momentum. Certainly not trying to lessen the impact of media. I think they have a vital role to play, but I also think it's about the individual's experience with the process.
So, Joe, I was on a webinar with the Department of Trade and Industry and others, and in fact, quite recently on a SARIPA webinar with journalists from the mainstream media, and they like to obviously report on the SOEs. Let's be honest, ESCOM, let's say SABC, certainly SAA, and others, and Post Office, etc. So they seem to be quite focused on the SOE space when they're talking about business rescue. Obviously, what we do to a large extent, all of us, is work in the SME space, or let's say large to medium companies. How do you think we need to, let's say, interface, engage with the media to get them to start reporting on what we do?
Interesting question, because it is the larger names that always sort of attract the headlines, and the more sensationalist, unfortunately, the better, and that doesn't necessarily play into what we're trying to promote. And it's true, we operate, the majority of us, at a SME level, and they don't necessarily get the airtime with the headlines. The session that SARIPA ran with the media, trying to also educate them, what is business rescue, where can they assist and help in promoting the process, is an important one. But our commentary, for example, as a professional body on liquidation statistics, that gets out into mainstream media. And that's an important component, that we're able to share those stories, that narrative, when we're engaging with media. It doesn't necessarily just need to be large matter specific.
Gideon, just talking about statistics, and I'm going to ask Vianney in a minute to just also give us his view. But Gideon, you've done some work on engaging with business rescue practitioners to try and get statistics into the tent in relation to things like business rescue dividends compared to liquidation dividends, success stories. And how have you done, and where are you now with trying to gather in all that information?
Yes, thank you, Eric. Interestingly enough, before I answer your question, I just did a bit of research, and when we refer to the word media, the question popped up, who is the media in South Africa specifically? And it was quite interesting. My quick research showed me that the media, if we refer to the media, there's print media, there's no less than 15 platforms or newspapers or printed media that actually is currently in our market. And I specifically use the word no less. It's not the max, it's the minimum. Secondly, if we look at broadcast media, there's no less than 5 local broadcasters in this regard, and this is TV broadcast. Radio, no less than 10 radio stations, and listen to this, astounding, and 200 community radio stations in South Africa. Then we've got digital and online media. There's no less than 8 platforms. We've got social media platforms, which is our Twitter or X, Facebook, YouTube, WhatsApp, LinkedIn, and the general internet. So, as Joe mentioned, how do we manage this whole perception? And that is when I realized, from a business rescue point of view, or from a professional body point of view, it is absolutely critical, and the onus is on the industry and the business rescue practitioners to actually communicate the success stories. There is no platform, to my knowledge, where we can actually go and change this perception. There's no written report or results that we can publish to the media, and that is what triggered me, to start investigating this. And we will roll it out later in the year, as an industry, or this is at least my vision, is that we actually publish physical journals or documents which can be in print form and online form, that we can communicate our success stories and actually find out what are the true successes of business rescue. I recently, I'm in the process of upgrading my license, and I, looked at my personal success as a measurable, and and the question is, without me disclosing my personal success, which I believe is quite high, the question is, how do we as an industry define success, and how are we going to define it going forward? And I think that's where a lot of the work that Joe and the team at Deloitte, have been running in the past years and for the years to come. So I think we have to actually define the measurable and then start reporting on that and changing the perception in that regard. Thank you, Eric.
Gideon, just from the interface with business rescue practitioners and gathering in statistics on things like success rates, business rescue dividends compared to, let's say, liquidation dividends, etc. Are you able to actually get that information out of the business rescue practitioners? Because certainly that's not available at SIPSI. I don't think they have access to that level of information.
Eric, the SIPSI is definitely tightening up, the reporting metrics, and they are engaging with the professional bodies, in this regard. And I've actually, and I'll talk about that a bit later, just looked at the business rescue practitioner statistics, over the past 5 years, which were quite interesting. But to answer your question, this information is not really readily available. We always hear of complaints from our bodies, SARS complains that there's practitioners that, or there's a lot of post-commencement taxes not paid, and they complain about practitioners. In certain instances, the banks also have negative experiences, and other role players. And in actual fact, we should get to a point where we have all the information and data shared, be it on a secure platform, but we must have an agreement of what data we share in an attempt to actually better the product of business rescue. But at this stage, this initiative would be driven by the feedback and report back by the practitioners, which information they share with the bodies. That's extremely important.
Thanks, Gideon. Vianney, we spoke earlier or late last week about SIPSI, about statistics, about the good news stories, which we've spoken about actually earlier this year in SIPSI Forum and last year. Maybe share with the audience or your thinking from a media perspective, how we improve the story of A, and B, statistics-wise, where you think you guys are going in relation to the success pieces of business rescue outcomes.
Thank you so much, Eric. Yeah, I think, Eric, we cannot downplay the role that is played by the media, particularly the mainstream media. As you might have been aware that in last month, talking about the deregistrations of companies that were non-compliant to annual returns. And that is a role that CIPC believes that we need to take and communicate, considering the widespread of this information that can go if we are to use the mainstream media. But in terms of the communication that is going out, we have observed as well that we are overwhelmed by bad publicity rather than to communicate good stories that are happening. Probably we're a bit cautious in terms of that information, or probably we are modest enough that we don't want to communicate successes. But I think it is high time that we begin to communicate the successes that the industry is going through. And as CIPC, we are engaged then in ensuring that we do communicate, and we have came up with a program of engaging the media houses as you have alluded to the program that we had late last year, where we had some of the media houses as part of the program, and we have made a decision that on a quarterly basis we need to communicate the reports pertaining to the business rescue that we receive. When it comes to the data that we receive, sometimes we're a bit challenged because any information that is filed with CIPC becomes public information. And some people then, they might be then cautious in terms of what they submit, particularly in terms of the information that you ask pertaining to that regard. So what we are doing then is that we are trying to tighten in terms of the reporting that is being done to ensure that at least it gives information that can be used for decision making by other role players. So we're doing it in phase approach, including some of the matters that we believe that these ones are the matters that needs to be reported to. And then subsequent to that, then would look at the information that will be adding value and will make life easy for decision making and also for policy makers to be able to drive this process forward.
Thanks, Fiani. So there's an active engagement now between SIPC and the mainstream media. And of course, your quarterly reports that you push out on statistics would obviously be looked at by them. Would there be any thought maybe about having, when you release your stats, to maybe have a session with the media to explain and take them through it? Is that something that you think about?
Yeah, it's something that we're considering in terms of how we're going to engage with them. So we are looking at the process of engaging them, educating them so that they understand, because business rescue, it's complex. For them, probably success will be something that they have a different lens of looking at it. So we need to be able to educate them so they understand what exactly business rescue is all about. And also they need also to understand that in some instances, what we may perceive as success might then not success, but it is success to those that are affected because they will have agreed on the plan and approved the plan. And if then we have a plan that is substantially implemented according to that particular project, it is a success because the plan has been successfully implemented. Thanks.
Thanks, Fiani. Ian and Harry, I'm going to ask Ian to go first. Just your general overview on this discussion. Ian, your thoughts?
Thanks, Eric. Yeah, I think there are a few very good journalists out there who understand the business rescue process very well and who are able to disseminate a story very well, be it a good news story or otherwise. But, just echoing the sentiments of some of my colleagues on the call, it is absolutely up to the BRPs to bring the stories to the attention of the media and not to wait for the media to come to them. Everybody in the public and in business wants a good turnaround story, especially in the context of South Africa, where we've endured so much economic hardship for such a long time. As you correctly pointed out, there are some very good stories, and not only big stories about SOEs and so forth, but there are great stories out there about medium-sized and small ones too. And hats off to Gideon and his team for bringing these to everyone's attention through the work that he's been doing. But every turnaround firm, I believe, that is proud of what they do should have a strategic communications agency on call who can bring these stories to the attention of the most suitable media outlets when success is achieved, whether it's the approval of a business rescue plan or the successful implementation of a plan or the successful execution of a sale mandate that's been envisaged by a plan. It's also very, very important for the industry, the business rescue industry, to get ahead of bad news on business rescue and to get to key media early in the rescue processes. In other words, the strategic comms firm should be employed on the matter right from the outset and not only when things start getting heated. We often wonder why the good news stories are not told. And, I joked with somebody the other day. I said that perhaps the problem is that at the end of a successful business rescue process, the BRP has absolutely nothing left in the tank with which to pen a story or to do a radio interview. We cannot emphasize enough the level of skill, execution, and sleepless nights that a business rescue practitioner has to endure in order to achieve a successful outcome. But good storytelling is so important, and it's important to get experts to tell the stories. Case studies are very important, but until you can humanize the experience for the media and for other stakeholders, it's just a very dry story. But the real stories about saving jobs and communities are very compelling stories. And, if those are not told, then soon we get to situations in the media where the BRPs are just shouldering the blame for everything that went wrong in the process. So my message is and a lot of us do employ good strategic communications experts. Find someone who shares the same values as your firm, and use them from the outset on every matter. Just like we as BRPs and turnaround experts need to be involved right from the outset of the matter so that we know, so we've got our finger on the pulse and we've got a good feeling for what's going on in the matter right from the beginning. In exactly the same way, the strategic communications expert needs to be involved in the matter right from the start. Thank you.
And Ian, from a timing perspective, I mean, from what I've seen, the great majority of media reports will be, well, the first meeting happened, this is what more or less the presentation said, and that's it. And then when you have your voting, well, the percentage was X. From a timing perspective, when should the BRPs be engaged with the media, do you think, and how early?
Well, right from the start, not just to paint the picture of what happened in the first vote and so on, but to paint a picture of the conditions surrounding, the employment and, environmental conditions that might exist. And, it needs to tell a story. Otherwise, as I said, it's just a very cold, dry report, That's why it's so important to employ experts to help to paint a picture and right from the outset, so that they can report right from the outset when the company's gone into business rescue, so that they can start reporting around the reasons why it went into business rescue, why the company took the decision, why it employed this and that business rescue practitioner, and what that BRP has done in the past, for example.
Great, thanks, Ian. Harry, your sense of the conversation, Harry. I know that at the summit, I think you had some views on the narrative, let's call it that, when it comes to rescue, and from a banking perspective. And I'm asking you for your personal views, not necessarily the bank that you work for. Harry, you're on mute.
Firstly, thanks, Eric. Firstly, I just want to thank you for including me on the panel. It's very kind of you, and the webinar. In terms of the stories we're discussing now, there's a bias to the larger business rescues, the high-profile, listed companies, and we tend to be conflating all of that. When we talk about business rescue, we're talking about a lot of applications, many of which are below the level of where we tend to be involved. So I think I want to just second Vuyani's original statement about the fact that the press or whatever reporting tends to happen is very negative, mainly because the press is sensationalist and the media likes to pick on the negative points. So there is an obligation on the business rescue practitioners in the bigger matters to actively advise, if not a little bit more, as Ian has said. It is about getting your story out. The banks are very nervous of this kind of situation, simply because information flow through the press is always viewed quite negatively, irrespective of what the news is. Remember that in our scenario, confidentiality is key, and we want to be dealing with the clients. So if I can give you the perspective that I think would work in our environment, is what we want is the press to be advised further down the line, rather than, as Ian said earlier in the process, with a little bit more of the hard tech rather than the marketing material. That's where I think we would be very uncomfortable to be reading about businesses we are lending into in the press. I think that creates a lot of stress in the system. So there is this conflict between the two positions, but I think people need to understand that the banks are generally very tightly controlled in terms of their confidentiality arrangements. And one of the problems of BR from a banking perspective when it comes to communication and data is how quickly we're advised of what's happening. So yes, this is post the BR getting involved in managing the market expectations. But again, I think the conversation links to the higher value companies, the listed entities. Below that, this conversation, I think, changes dramatically. But yeah, I mean, I'm very supportive of Ian's suggestions. I would just prefer them to be confidential and first to the banks for obvious reasons. But that's a different
Yeah,
that's a
banks don't like
different
to be.
issue, a slightly different issue than managing the marketing of how well a
Yeah.
BR is going or not. In fact, I think all press on a BR is unfortunate, except for perhaps at the end of the day when TMA and SARIPA come to the market to explain how well or something has a BR has gone and what actually the positive results of that are. That's where I would love to see more focus. And I think TMA and SARIPA are working on it quite well at this stage of the game, and hopefully it'll get better and better as time progresses.
Thanks, Harry. Well,
Pleasure.
that's a nice segue into Joe's question, or my question to Joe, and that is, let's just focus now on an organization like SARIPA, which Harry mentioned, and of course there's TMA and there are others involved in this space. What role does a SARIPA play, Joe? And you've been recently elected as chair. We congratulate you. And being in there for a few months now, Joe, just your sense of the actual role that SARIPA can play. And I'm not talking about focused on rescue. You know, obviously insolvency is part of what SARIPA does, but just looking at the business rescue narrative. And I know we have summits and we talk to those, preaching to those that know about what we're talking about, but how do we extend the narrative for business rescue or in favor of business rescue through a SARIPA?
Thanks, Eric. So the SARIPA board and I met on Friday last week. So this conversation is actually very, very well timed. Really to unpack what is it, what is our vision, what is the objective of the organization. And for me, it really comes down to a number of key items, and one being education. So driving education, and if we're talking about business rescue, driving education of stakeholders around business rescue and of business rescue practitioners. So from a SARIPA context, that extends into actual courses that are run, and those are generally in conjunction with Insol International, so cutting edge best practice courses delivered by professionals, you know, at the top of their game. So I think that for us is very important. Education delivered through webinars like we're doing this afternoon, conferences, summits, and constantly looking at the channel of that education, whether, you know, even programs like mentorship actually boil down to education. So education being for us a key pillar of the objective of an association like SARIPA. Then you look at discipline, and I think that is also equally important for us, is that there is a code of conduct that underpins every member of SARIPA. And that has value. It has value for our stakeholders. It has value if you put yourselves in the shoes of a bank. There is a business rescue practitioner appointed. They are a SARIPA member. That means that there is a process when a standard which is expected is not met. And for our members, that process that follows is transparent, efficient, and fair. So, you know, actually adhering to a code of conduct, and from a SARIPA perspective, making sure that the disciplinary process is robust is very important. And then advocacy, so being there for our business rescue practitioners. Again, the SARIPA much broader than just BRPs, but limiting it to that for this conversation. Being an advocate for our BRPs in either championing causes where there is collective challenge and even on a one-on-one basis. So I think for me, if you're saying, how does SARIPA help to promote business rescue? Well, it's ensuring we have the best quality BRPs that are members of, get their license designated through SARIPA, that we have a process that brings value to that designation, which is really adherence to the disciplinary code, and that we are there to support our practitioners with challenges that they may have through the discharge of their duties.
Harry was mentioning, obviously, a major role to play on the part of a SARIPA in educating, whether it be the media or obviously the general public out there, and of course directors. And we'll come back to the role of directors in a minute. But Joe, I think the new Insolvency Court, the role of that court going forward is a game changer. I think we're all very excited about it. In fact, yesterday was the first day I think they were taking submissions, or let's say launching of applications or filings, let's say on the 14th of April, it really is a very fresh process, and we'll see how it unfolds. But ultimately, we are hoping to see excellent results coming out of this court, good judgments, expert judges hearing matters on an expedited basis. And I think, SARIPA played a major role in getting the Joburg court up and running, and I think very pleased about it. Just what is your sense about how that's going to change perception of business rescue, looking at expedited hearings and good judgments coming out of those courts?
Well, Eric, I think it would be remiss of me not to acknowledge the part that you played in getting the Insolvency Court up and running. So it is really I know for me, a massive thank you to you, to Haroon, to Renee, to Colin, to all of the council that were involved in this. It is, as you've said, for me, a game changer. And what does it bring? It brings what you've just mentioned. It brings hopefully well-constructed judgments. But for me, it's about the time that to deal with matters through a court process. Because in our world, time is everything. These matters are urgent. We also see a lot of litigation, sort of spurious litigation, trying to delay matters. If we have an expedited process to deal with that, it brings efficiency into the process, which for me, again, if you're looking at how do we elevate business rescue as a process, creditors, other stakeholders involved in the business rescue, the employees, the shareholders, all want to see issues and problems and challenges resolved expeditiously. So for me, it's I am hopeful that this pilot is going to be incredibly successful, and I think it is incumbent on all of us to ensure it is so.
Yeah, and I do think the ultimate goal is to roll out similar courts in Cape Town, Durban, other centres as well, which is very, very exciting. But Ian and Gideon, just your sense firstly on the new Insolvency Court, and then just your views on the actual role that the BRPs can play. I know we've touched on it already, in respect of delivering good outcomes, publishing plans on time, not kicking the can down the road, and most importantly, being brave enough to say there's no longer a realistic prospect of rescue. Let's place the company into liquidation. So I've given you quite a bit to answer, but let me start with Ian, and then Gideon can give a view.
Thanks, Eric. So when the need for the specialist insolvency court was highlighted at the inaugural SARIPA Business Rescue Conference in September last year, the things that were emphasized were that lenders and shareholders cannot really be expected to embrace business rescue until such point as regulation can effectively deal with, inter alia, the business rescue practitioners that go rogue, and hold a company to ransom. It was emphasized that a specialist insolvency court would be ideally positioned to assist the CIPC with the difficult task that they have of regulating business rescue and the business rescue industry, and of streamlining the practice of business rescue. And it was also emphasized that once we have a specialist insolvency court that is working properly and working with the required level of urgency, that lenders and shareholders will be much more open to embracing business rescue as the preferred mechanism and the most well-equipped mechanism for saving companies in South Africa. So the Specialist Insolvency Court can only be a positive thing for business rescue in South Africa and for underpinning the revival of the economy. So huge congratulations to you and everybody else who was involved with the introduction of the new court on a trial basis. Now it's just a case of seeing it work as it was intended. But we are very excited by the prospects for business rescue and the turnaround profession, as well as the benefits that the court will have for SA Inc. In the long term. The second part of your question, Eric, about the role of BRPs, and it's about achieving a better image for business rescue, really, at the end of the day. And the way in which that can be done or needs to be done, the part that the BRPs need to play is they need to demonstrate at all times that they are trustworthy and competent. And they need to, Joe used the words transparent, efficient, and fair. The words that I like to use is that BRPs need to demonstrate that they are trustworthy and competent by acting with transparency, with purpose, and with speed. And, when we talk about transparency, I remember Peter van den Steen's words last year at SARIPA's conference, which resonated very strongly. And that was that creditors, it was something along the lines of creditors deserve nothing less than absolute and complete transparency from the BRPs. And without exception, the BRP has this duty towards creditors. So our duty to creditors is to tell them the plain, unvarnished truth at all times. When we talk about purpose, the most robust, practical, and balanced plan that is possible under the circumstances. So where Joe talks about fairness, I talk about balance. The BRP must have the required skills, the required trusted skills at their fingertips. They must know when to deploy them, and they must be able to deploy them at a moment's notice. I often say that the BRP, and I know most people agree with me, a single BRP cannot have all the skills required in order to do business rescue and turn around properly. He cannot possess those skills himself in person, but he has to be surrounded by a trusted team, or he has to have trusted people at his fingertips that he can call in when required. And then the third aspect is speed of execution. Business rescue needs to be used more as an in and out mechanism or tool to implement the remedies that are available in terms of Chapter 6. The idea should not be for the BRP to try and achieve a state of business as usual while under the moratorium of Chapter 6. The problem with drawn-out business rescues is that the risk of failure and falling into liquidation is just looming too large all the time during the process. For a company's stakeholders, business rescue status, the status of business rescue equals uncertainty, and uncertainty is everybody's enemy. The more that a business rescue can be styled or the more that a business rescue can be planned and scripted in advance of the commencement of the process, almost in a pre-packed style to the greatest extent possible, the quicker the company can get in and out of business rescue, and the better the chances of success at the end of the day. Thank you.
Thanks, Ian. That was very, very well put. Gideon, just quickly off the back of what Ian was saying, we hear the narrative. BR doesn't work. BRPs are only interested in their fees. The process takes too long. And this is the general statement. We just don't like BR, right? That's been out there. It's not a surprise to many of us. But just from your experience, is that the case? Are you seeing sentiment change? And how do you reposition that narrative, in your view?
Yes, no, I agree with everything that Ian said, and perhaps, I can further his position with a thought, or leave everyone with a thought. And, dealing with various stakeholders on various levels of the banks, in the business rescues, be it small, be it large enterprises, the question came up, is it not time for each affected person to realize that he is a stakeholder in the business rescue, and that each stakeholder should actually define and communicate what their preferred outcome would be in a business rescue. And obviously, it's not always possible to actually achieve all objectives. But when we talk about a success rate, a success of a business rescue is not always just a successful trade out or a successful sellout. There are other factors that often is not talked about, such as employment retention, maximizing a return to creditors rather than would be received in a liquidation if a business is sold out, continued supply, and then also the effect of a business rescue on the fiscus, actually recovering outstanding debt, but also continuing to contribute to the national fiscus in this regard. So, perhaps we should actually change our perceptions. And, when we go into a Section 147 or 148 meeting, let's rather say we would like to see this objective being achieved. And the business rescue team can establish a objective matrix, and that can be the guidance throughout the business rescue. And then when we say let's talk about the success of a business rescue, let's go and look at what objectives were tabled in the beginning and what were really achieved.
Yeah, thanks for that, Gideon. Harry, when Gideon talks about partnering or bringing along stakeholders within the business rescue framework, of course, the banks are probably the biggest exposed and have a lot at stake, never mind the securities they rely on, etc. Is that, do you think, practical, possible? How close can the business rescue practitioner get to the major creditors to get them to buy in, work together? And what are the touch points which promote that, let's say, engagement, Harry? And then I'll ask Vianney for his views.
So, Eric, I think everyone is aware that a bank's major preoccupation with business rescue is effectively perfecting its security and making sure that its security is not compromised in any way. So fundamentally, the whole business rescue process starts or originates at the directors of the company just before they determine that they need the business rescue process to protect them. Ideally, in the ideal world, the banks and the directors are talking to each other well in advance of that. Ideally, the bank has, through covenant management, identified that there's a problem and proactively engaged with the directors to come to the point where everyone agrees, and we all know the stories, where a chief restructuring officer is appointed, where a potential business rescue practitioner is identified, and a plan is agreed by everyone, or at least some sort of a plan is hobbled together, and then all stakeholders are engaged to try get to a solution. It doesn't work that way in practice all that nicely. There's unfortunately the two factors, I think, the most determinative factors of a business rescue being successful are competence and disclosure. Often the competence factor is lacking both in the directors because they're looking after their own interests, or there's other elements at play, be it fraud or other problems. And in the disclosure environment, not all the facts are put on the table early on. So a business rescuer's job is unenviable. The banks look to the business rescue practitioner to protect their position. The business rescue practitioner is put under immense pressure from all stakeholders, some of which are not being honest, and some of which are not making full and frank disclosure. So a business rescue practitioner is not just the person who comes up with a plan with the creditors to implement the saving of a company and its jobs. They also become the forensic detective. They also become the enforcer. There's a lot of difficulties that we've identified as banks, and we tend to take a very narrow approach if we can. Our approach is focused specifically on assisting business rescue practitioners to get to the outcome of realizing our security for the highest possible value. And that is unfortunately where a lot of the noise interferes, because business rescue practitioners are literally being pulled apart in our experience by trying to deal with the competing interests. I'm not sure that that answers the question fully, but the banks, because of the complexity of business rescue, try to narrow their focus as best they can. Often we will support companies that we lend to, as long as the business rescue practitioner has a very clear picture of how they're going to get to a substantial implementation position. And that's why I say to you, this whole conversation revolves back to the level of competence and the level of disclosure that takes place. Those are the two major factors that we constantly look at least in my personal involvement in all matters. That's what drives the thinking.
Yeah, and Harry, the other point that you've raised before is the level of communication between the BRPs and the stakeholders, including the banks, of course. Does it happen often enough? Is it as transparent as Ian's alluding to, etc.? That must be an enormous source of frustration, I would think, in certain matters for the banks.
Well, you'll find that in the smaller matters, there's no disclosure. There's no engagement. We're taken usually by surprise. And that's very problematic, Eric. That's what creates a lot of the negativity around it. In the larger matters, it's not so bad. The BRPs we tend to engage with are hugely competent. They have depth in their offices, and if they don't, they hire good consultants. I could do some grey marketing here for some of the guys, but I won't. The reality is that the larger the matter, the more competence and disclosure you get in the format that you need. The smaller the matters, the less the trust factor applies, because it's opaque, it's by surprise, and banks are generally scrambling to secure themselves or to ensure that their security is perfected. It's wholly inadequate in that respect and at those levels. That's the reality of the situation. There are exceptions. It's not, we're generalizing and we've got to be careful with that. But the point is that also depends who the professionals are that are involved. The law firms, many of the better law firms advise their BRs correctly. Those meetings with the banks are held, at least from our perspective, wherever we've been engaged, we come with a proactive, positive response. And often it's a conversation. Where we haven't been engaged and where we're taken by surprise, it's quite a difficult hurdle to overcome. That trust element that enables the banks to work in a sort of supportive way. And then that's where the fear comes off, because now there's a moratorium, now the security may or may not be perfected, and now you're dealing with people that haven't even spoken to you. And that includes your clients, potentially, the directors who you were funding and who you trusted. So you can see that there's an immediate break in the trust relationship. So the good advisors advise the customers, the clients, the companies in distress to immediately speak to their banks. The fear of the company is that if they speak to the bank too early, the facilities are going to disappear, and there's going to be a sort of if you want, an acceleration of the default phase. And I'm not going to say to you that hasn't happened. It has happened in some circumstances, but it's almost always driven by what's the cause of the distress. If the cause of the distress involves some element of dishonesty, there's a less than positive comeback from banks generally. If it's due to market disruption, that's a different story. And I think COVID was the best example of that we've lived in our recent history. So yeah, I hope that somehow addresses what you've asked.
Thanks, Harry. Vuyani, we spoke late last week about the role of SIPSI, obviously looking at revocation of licenses, compliance notices in terms of Section 22. And you sent me a very interesting case that where SIPSI in fact applied to put a particular company into liquidation off the back of, let's say, non-compliance with the Companies Act. People can read the judgments as a reported decision, selective empowerment investments, where in fact SIPSI applied to court to put the company into liquidation for reasons that the judge explained in the judgment. But just listening to Gideon, Ian, Joe, and Harry, just your sense of the role that SIPSI can play in respect of pushing companies towards the more difficult decisions on whether they should engage with professional advisors. Does SIPSI have a role in relation to compliance notices? And as we're starting to see in the Nova case also, you issued compliance notices. Are you getting a sense that SIPSI are becoming much more involved and more proactive than you have been maybe in the past?
Yeah, notwithstanding the challenges that we are having in the manner in which the Act has been drafted, we will all appreciate that CIPC, though it's a regulator, but it's somehow a bystander because CIPC is not an affected person. So the business rescue then, it's like an activism kind of an arrangement for all the affected parties to be involved and be the ones then that are ensuring that they are taking these matters. However, CIPC is taking a strong stance in terms of the conduct and the behavior of the business rescue practitioners, because it is CIPC that is accrediting professional bodies as well as licensing the business rescue practitioners. However, when it comes to issuing compliance notices and also taking certain matters to court, we are also doing those, treading softly and also ensuring that we get our ducks on the row, because we do not want a situation whereby we are found wanting and people, they will take advantage of that. So that is why you will find few and fine between these cases. But when we have a case and we strongly believe that we have enough evidence to win the case, then we take those matters to the appropriate forum. Now, you will appreciate that the case that I sent to the judgment were also challenged in terms of local standing, in terms of that case. And we had to prove that we do have it, because as a regulator, we need then to ensure that companies, they are not trading recklessly. And so we do receive complaints either through the creditors using Section 186 to initiate a complaint, and then there will be investigation in that regard. In some instances, then we do receive reportable irregularities through the auditors or independent reviewers, and we take them from that angle. So as an organization, and what we have been preaching is that without having BRPs of absolute integrity or high integrity, it will be very difficult for us to succeed. We do appreciate that there are a lot of business rescue practitioners that are doing their best to ensure that we achieve the purpose of the Companies Act of ensuring that we balance the interest of everyone involved. However, if there is that small percentage, then it dilutes the whole thing, and people then tend to think that a business rescue and the practitioners, they are there to serve their own interest. Hence, we are keen to work with everyone so that we demystify the narrative and ensure that we uproot the rogue elements, as it were, that we find in the business rescue. What we are doing, indeed, we do frown at the business rescue practitioners that are conducting themselves in a manner that is unbecoming. We have suspended quite a number of business rescue practitioners. Currently, as we speak, we have 2 matters that are before the courts that we are dealing with. And we believe that we need then to stamp our authority, however, not having a regulatory overreach, but to make it a point that the affected parties, at least they have a place to go so that their matters are dealt with, because these companies, they are financially distressed. They don't have any other money to take some of these matters to court, as the Act envisaged that they must go to court. And hence then we are able then to come in when it comes to the conduct of the practitioner, and we are able to deal with those matters. Although it's not an easy exercise, because as it has been said, the level of transparency leaves a lot to be desired. And some of the practitioners, particularly on these small rescues, they don't even have enough resources to be able even to file reports. They will only file reports when their licenses have expired. So those are the challenges that we are going through. However, as CIPC, we have taken a strong position to say that we must make it a point that what was envisaged by the legislators in terms of the Companies Act in Chapter 6 to bring business rescue, we must achieve it at all costs. Having said that, we are going to embark on the training, and we're going to also check with the professional bodies in terms of the CPD programs that they are doing. How are they empowering the business rescue practitioners in terms of being effective in their role in executing their duties in saving the companies? Because it is not supposed to be a tick box exercise that you have gone through a CPD program and then your license or your membership is being renewed. But we need to see programs that are empowering the business rescue practitioners to deal with complex cases that they are meeting. And those CPD programs that we are talking about must be aligned to business rescue, so that the programs are talking to business rescue, not the general training that people they will normally get. So that's what we are doing. And I think as CIPC, through the Business Rescue Liaison Committee, we're making some headways, because the cooperation as well as the collaboration that we're having with the respective stakeholders, it is helping us so that we are able then to address the issues that are being experienced by the general public. It might be seen as if maybe it is taking time, but if we are to look back, we can really say that we have made some progress. If we are to look in terms of where we come from up until now. In the past, even the issue of getting data, it was a problem, but at least we have made some progress, and we are dealing now with the business rescue practitioners that are being found wanting, and also we are ensuring that we are following up with the professional bodies that are accredited with CIPC in terms of disciplining their members, because the accreditation model hinges also on the fact that CIPC believed that these professional bodies will be able to discipline their members when they do not comply with the code of conduct of their professional bodies. And all those code of conducts, we have gone through them, and when we were accrediting the professional bodies, we were comfortable that they will be able to deal with their members, and their code of conduct is aligned to what CIPC wants to see in terms of members. So at this moment, there is a room for improvement, but I think there's also a lot of work that has been done.
Thanks, Vianney. Joe, just on the point of education, we spoke a little bit earlier on in the session about the role of educational institutions, universities, and organizations like SARIPA. I did some research, and in fact, and off the back of what Vianney has just said, we've obviously got the Insol International SARIPA course for business rescue. It's now in its third year in 2025. The University of Pretoria offers a master's program in insolvency and business rescue. University of Johannesburg offers a learning program in rescue, and UNISA also, through LAWSA, also offers a program in business rescue. So the opportunity for business rescue practitioners to upskill and to, as Vianney says, get to a level where there's a real educational element to what they do is very important. And Joe, I want to hear from you just on that aspect. And also, obviously, we're working hopefully with SIPSI to get our course registered or maybe accredited with SIPC to become the go-to course for practitioners to be licensed. Just your sense of that. And then lastly, the Institute of Directors, for example, are very active in trying to educate directors in respect of business rescue. They pushed out a guidance note last year, which I assisted them with in relation to trying to educate directors on their role pre-rescue, post the commencement of rescue, etc. So this whole educational basket, I think, is very, very important for upskilling business rescue practitioners, and both junior and senior guys as well. Joe, what is your sense of all of the educational input that's available?
Oh, thanks, Eric. I think that for me, one of the most important points that Vianney has raised is about CPD, because as you've said, there's a number of different courses that are available that deal with, if I can call it, more entry level into business rescue, going through the law, going through the practice, but not necessarily dealing with complexity. So one of the tasks that we've sort of challenged ourselves with as a SARIPA board is what is available for senior practitioners. What are the topics that we need to address? Where is the complexity, the cross-border issues? And can we create forums and workshops to debate and discuss those? Because that then, from a CPD perspective for our senior practitioners, would perhaps carry a lot more weight. I think the variety of courses that are available, you've mentioned 4, those are all great. We're obviously, from a SARIPA perspective, very proud of our SARIPA course, which is run in conjunction with Insol International. And the lecturers on that course are professionals at the top of their game in this field. So really for us, that sort of sets it apart and provides the ability for students who are taking that course to interact with practitioners. So the ability to talk about real life cases and situations enhances the overall, I suppose, experience of that course. As I mentioned earlier, when you look at the objectives of SARIPA, part of that is ongoing education of our members and our stakeholders. So education, for me, absolutely critically important. One of the key stakeholders being not necessarily those that are members of SARIPA, but, as you've mentioned, Institute of Directors. And there it is about, in my personal opinion, continuing education and consistent education about what to do when faced with situations where your business is starting to underperform, experience financial stress, and ultimately distress. It needs to be continuously provided, because it is something that is difficult for directors to engage with, and whether that's right or wrong is probably the topic of another webinar. But it is not flavor of the month. It is not something that is positive, and there isn't necessarily the engagement with the topic that we would like to see. So for me, the continuous education from institutions like IOD, very important, such that directors understand exactly who to go to and what to do when situations start to manifest, as would have been explained in such courses.
Joe, the challenge that we've spoken about many, many times, as you have at the Deloitte Restructuring Survey, is how do you actually get to the directors? Yes, the Institute of Directors will publish excellent publications.
Yes.
And the media, hopefully, will talk about business rescue in the media. But how do you get into the boardrooms? And then I'm going to ask Gideon his view.
So many moons ago, decades ago, when I was working for another professional services firm, we were wanting to run seminars for directors on exactly this, what to do. And it actually got to the point where it wasn't viable to run the seminar because no one's going to turn up, because if I turn up and somebody else sees me there, do they then think that there's a problem in my business? So the perception of actually being at the seminar was the challenge. I suppose a little bit more helped in the more modern environment with sort of virtual, perhaps you can hide behind a screen, but exceptionally difficult to get directors to engage on this topic. Getting into the boardroom is about relationships. And I think it was the Deloitte survey of last year, which spoke about having situational experience on the board, making sure that the board, we speak about diversity, and diversity comes in many guises. And one of those is experience. So having somebody at the board that understands what it means to really practically turn a company around, operational turnaround, who can look at the board packs, who can look at the financials that are presented, the KPIs, and really zone in, drill down into the issues and make sure that there is a sufficient robustness around what needs to be remedied and the momentum needed as well. But it is something that we battle with all the time, is to get airtime at the right level, particularly when you have behind your name restructuring professional, business rescue practitioner. It's unfortunately, it's an immediate, or we don't have a problem. Thank you, but no thank you. And I'm sure everyone who's on this call has experienced, I hope I never meet you in business. It's funny, but it's a challenge, because actually if there's a challenge, please call me early.
We're the people that no one wants to sit next to at the dinner table.
Fortunately.
Lindiwe Buthelezi makes a very important point, and then I'm going to ask Gideon for his comment. And she says, to add on to Harry's point, the importance of competence of practitioners cannot be overemphasized. This is attributable to on-the-job training of BRPs, transfer of skills, accreditation of professionals, as supported by Marius Pretorius, and just generally the education of business rescue practitioners. I think, Lindiwe, we're all on the same page. And the point that you do make is, as soon as you get to that point, Joe, where you've got proper educational levels in place, and maybe we even get to our course becoming an accredited course, the confidence levels from the banks and other stakeholders will just ratchet right up. And then you're going to obviously have competency, which will not be questioned, because there's an increase in the skill levels of business rescue professionals. Joe, your thoughts?
Eric, yes, I agree. I mean, competence of BRPs is something that absolutely is a challenge and needs to be addressed, and goes, a long way towards uplifting the profession. I think you said at the beginning of the webinar, it's not just about business rescue practitioners, but it's all the supporting structures also being a well-oiled machine and fulfilling their function. And therefore, it is, from my perspective, hearing Vuyani speak and talking about some of the actions that SIPC is now taking, because that's what we want. We want a regulator with teeth, but we want the regulator to also take on the right matters. So appreciated what Vuyani had to say in terms of, let's make sure we have our ducks in a row, before we take action, but actually starting now to take action. And for me, it's about licensing the right people. It's also about ensuring that when it is appropriate, that those licenses are revoked. So for me, yes, competence important, and linked to competence is education. And so that supporting structure around business rescue, being the professional associations and the regulator, all very important.
Gideon.
Eric, I just want to emphasize and maybe talk to my fellow youngbloods and the junior practitioners. If you look at the statistics on the CIPC website, which was published, the most movement is actually taking place in the junior category, followed by the experience. The senior category is more or less stable and has been stable for the past 4 years. Currently, there's 323 licensed practitioners. But what I want to further emphasize in terms of the educational courses that SARIPA actually runs with Insol is about 2 years ago, I was one of the students. I think I was actually of the first program of the South African insolvency law, a student. And in my view, a business rescue practitioner cannot go, who's not an attorney, I must also interject myself, but he cannot practice if he hasn't done this course or a similar course, accredited in South Africa. And the reasons be is you're faced with legal decisions, legal scenarios. You need to understand securities. You need to understand what the impact of your decision would be in the case of a liquidation. And, I can just actually emphasize the critical importance of these educational courses for the SARIPA members and everyone else that is interested, and encourage them to inquire and to actually run the courses in this regard.
Ian, any thoughts?
Yes, Eric, I strongly endorse these courses, especially for people starting out in the profession, regardless of their age or experience. We used to put all our people on Professor Morris's CRA course. There are obviously more courses available now, and I know I recommended the SARIPA Insol course to somebody after I'd read the write-up on the course, and they completed it last year, and the feedback was exceptional. So I think it gives them a solid grounding in business rescues disciplines and the ways of thinking. As the way of thinking in our line of work, it can differ, or is actually it's an evolved way of thinking compared to business as usual, and it allows these people new entrants into the profession to network with key people in the profession, which is very important, of course. And once they have this grounding, then I believe that on-the-job experience is the most vital element of learning. However, BRPs and turnaround practitioners can, of course, refer back to their course material when they need to, if they need to refresh their memories on something or whatever the case may be. And they can also register for specialist courses if there's learning required for a specific direction that they may be embarking upon, or something specific that an assignment requires.
No, thanks. Piffarello, Charles says here that the special court, we should maybe send some of our BRPs in there to train judges. I like that. It's refreshing. I do know that the judges will certainly be quite senior commercial judges. We haven't yet seen the panel that will be put forward as the judges for the court, but I'm sure that the DJP will be telling us who those judges will be very, very shortly. So that interesting suggestion. Joe, just quickly, and I'd like to hear from Vianney first before Joe, just Department of Trade and Industry last year, I think it was last year, had a session with SAICA, South African Institute of Chartered Accountants, and a big debate was held about the role of SAICA as stakeholders in getting directors and boards to start thinking about going concern issues, their obligations and duties in terms of the Companies Act, trading recklessly, maybe trading in insolvent circumstances, and just the whole concept of financial distress, and whether or not auditors can play a role in pushing the decision, or let's say the consideration around a 129.7 notice, or potentially filing for rescue in terms of Section 129. Vianney, your thoughts on the role of SAICA and the auditors? I know you've got a view because we discussed it the last time, and then I'd like to hear from Joe being at Deloitte and just your view on the role of SAICA. Vianney?
Yeah, so Eric, we do receive reportable irregularities from the auditors. Particularly those that are IRPA registered, not necessarily SAICA, which is the ongoing exercise that is happening. That's what we do on a daily basis. There is a business unit purely focusing on that. What normally happens then is that upon receipt of that, then a compliance notice will be issued to a company. And what happens thereafter, we normally receive then the response from the companies, because they have to respond in terms of the complaints notice, in terms of how they're going to remedy the situation. We do receive more often than not confirmation that that is the case, and the company has put measures in place in terms of addressing that. We normally term that the subordination agreement. So there is a kind of an arrangement that they do with their creditors, and that then will be provided to CIPC, and that then agreement must be signed also by the parties that they are saying they have agreed that here is an arrangement that they are going to follow. And if that arrangement then is put in place, then that triggers then for the business unit responsible for enforcing the financial related matters, then to review it on a regular basis to check how far they are. And if there is progress, then they will then notify the company accordingly, as well as also the auditor concerned. And when there is then the next cycle of reporting, they will have then to come back to tell us. That's what normally happens. And then if then it is, we received a complaint, as I've mentioned, in terms of maybe a party or a creditor invokes Section 186, then we'll conduct then an investigation. And most of those then they are purely based on the fact that there was non-compliance with the Companies Act. Now we are, as CIPC, we are open to all the collaboration efforts that are aimed at improving the work. We have not been made aware of the engagement that the mother department, DTIC, that had with SAICA. However, we are working closely with SAICA, as we are working closely with SARIPA and other TMA and so forth, because we have our regular meetings and issues of common interest. We discuss them, whether as a committee or as bilaterals, and we discuss those. And you will also appreciate that we were also invited by SAICA. I think it was a year before last, where we had to have a talk at SAICA. So we do have engagements with them, and there is a business unit that purely deals with those matters on a regular basis, and we give them a special attention that we attend to them.
Thanks, Vianney. Joe, your thoughts on the role of auditors signing off financial statements? Are they involved enough? Should they become involved at a higher level?
Yeah, Erica, perhaps just to mention, the last time I was auditing was over 20 years ago, and the audit profession has changed significantly since then. But what I can say is that for me, where the auditors do play a role is in their opinion on going concern. So a set of audited financial statements are generally historic, but it's the going concern opinion that is forward-looking. And that is generally from the signing date of the financials 12 months forward. And within that clearly falls the 6-month test for financial distress. And the robustness of that test is really, for me, where an auditor's role is fairly critical. Now, my team and I have been involved when we support the audit team at Deloitte with clients where there is concern, and that going concern piece is a significant piece of work to be able to support the ultimate conclusion, whether that be a clean opinion, a qualified opinion where there is an emphasis of matter, or at worst a disclaimer of opinion, so no opinion is actually provided. And it really comes down to, for me, the cash flow forecasts that are made available and the depth at which those are tested and the assumptions, they really kick the tires. And from a solvency perspective, really understanding what's happening on the balance sheet. When we have worked company side, so we are supporting our client, which is an entity, and the only way in which we can do that is when Deloitte is not the auditor from a conflict perspective. We often face off against other audit firms. And there, it is interesting to note sort of the varying depths that different audit firms go to in terms of determining going concern. I think it's one which needs a lot more attention. But there's always this tension with auditors and the clients around fees and costs. But ultimately, your duty is to provide an opinion, and that opinion has to hold together with the audit evidence. And the audit evidence needs to be, if they're particularly in a business where there are concerns, a robust cash flow forecast looking at liquidity, an in-depth analysis of the balance sheet looking at solvency, so that the readers of the financial statements can use the information contained therein to make decisions.
Yeah, I think an engagement with the relevant people at SAICA and a SARIPA would go a long way to having quite a robust discussion on exactly what you've just said. And that is, how do they actually see their role going forward in South Africa from a financial distress red flag position? And maybe we can think about that, Joe, going forward. Harry, just talking about red flags, we always say the banks are probably, besides the auditors, the first parties to know about financial distress. They probably see the red flags quite early when covenants aren't being met. Just your sense of whether the banks can play, and I know there's all sorts of confidentiality issues and reputational issues. Can the banks play a more active role in maybe nudging, that's probably a good word, nudging the directors closer to a discussion with maybe their legal advisors, auditors, or financial advisors on a decision in respect of going out and getting help at a much, much earlier stage along the distress curve? Or Harry, do you think giving boards a steer in that direction is just, too difficult or too far a bridge to cross? Your sense?
So, Eric, I can only really answer based on practical examples that I've been involved in. I can't generalize for the other banks. And all I can say to you is where we have seen early financial stress or where we have been privy to that with our clients, our deal teams actively engage with the directors of the companies. I've personally been in meetings where the statement has been made to directors that they are potentially exposing themselves to personal liability, given the forecasts, the cash flow forecasts, and the problems that have been identified. So I don't think it's an unreasonable statement to say that every good bank that has a handle on the financial position of its clients is having those conversations, assuming that the bank director relationship is on solid footing. I think those things are raised. They are raised as early as is possible, but it's an imperfect world. Often the information that banks get are after the fact information. So, if you will, the horse is bolted because we're getting, usually what you'll pick it up on is management accounts, depending on those covenant reporting usually happen quarterly. But we do. The short answer to your question is we do actively engage. Can we do it earlier? We tend to do it as quickly as the information is assessed and a red flag is raised. But remember, the determining factor of whether a business rescue resolution is something that's going to be considered is always at the discretion of the directors, and they make those value decisions. We have actively referred directors to lawyers, to legal advisors, and to their accountants and said, you need to get advice on the application of the business rescue provisions. So we have done that in quite a few circumstances. And generally the advice is taken at face value. And of course, it then gets a little bit more difficult because the conversations turn to more mundane things like facilities and securities. So we're not really the best partner in the process to be raising these things because it creates a great deal of stress for companies. But do we do it? And is it something that we are actively involved in? The answer is yes. And I think it does cause a great deal of consternation because sometimes the directors who need the help the most tend to understand their financials the least. They delegate it all to FDs and CFOs and don't worry too much about it. And then the poor FDs and the CFOs are in deep trouble in the sense that they're under pressure to escalate these things to their general board. And I think Joe's point is exactly right. It's when the auditors arrive and start pointing out that things don't look so healthy that the proverbial hits the fan. But we do it. And yes, there is a role for the banks to play, and I think we are active. We don't strong arm, but we do certainly raise it quite loudly and clearly. Look, a bank can send a message as well. It can reduce your facilities by saying
Sure.
you cannot afford what what you think you can. So there are various tools available to us, and we do use them. We do use them as best we can. Sometimes withdrawing facilities or reducing them is not the way to go, Eric, because you create more distress and you put more pressure on companies, and that's not what you want to do. That's not the way we tend to operate. But in any event, I hope that answers your question.
Yes, it does, very much so. Thanks, Harry. Just we're going to wrap up now, but just Gideon and Ian, one of the suggestions from Alison, which is a very, very good one, is that yes, we can have courses, and courses are important. Education is incredibly important, but what about practical experience? How do we get junior BRPs into the tent to get them to actually have live training, practical training? Very difficult for junior practitioners. They might have licenses, but they might not really see or be exposed into a live matter. Just your sense quickly, Ian, and then Gideon.
Yeah, Eric, I think it's very important that juniors be given the opportunity to train in practice. And I think, it can benefit the firm as well. It's obviously, you need somebody to do, there's always a certain amount of work that's required that doesn't require a senior person. I think it's obviously a junior person. Most junior practitioners are prepared to work at a fairly low cost just to get the experience. So for any firm that is sort of employs sort of 5 to 10 people or more should be actively looking at bringing on junior practitioners to assist them with their work. To give the junior practitioner the experience in the interest of the profession as a whole, and that person, and B, to assist themselves with with expanding capacity as required at a fairly low cost.
Bjorn, you agree with that? How do we get our more junior practitioners up to speed, other than maybe joint appointments?
Yeah, apart from joint appointments, we have raised the matter with the DTIC to probably engage the Department of Small Business and Development, probably to also incentivize these SMMEs to make use of junior practitioners. You'll appreciate that when the company is in business rescue, they would not have time to experiment with the junior practitioners. Then they might want to make use of a senior practitioner. And again, if you are to have joint appointments, it means now you have 2 practitioners that the company needs to service and pay for their fees. So whilst we are supporting the issue of hand-holding of junior practitioners by experienced practitioners or senior practitioners, but you have engaged the department to say, please speak to the Department of Small Business, and they should find out what role they can play in ensuring that these SMMEs, though they are struggling to get the post-commencement finance, can they incentivize these companies when they appoint junior practitioners, so that also they get up and they get some experience against their years, so that they are able then to get the work going. Having said that, we are also encouraging the professional bodies to ensure that they have programs in place to make it a point that their junior practitioners, they are taken along. There is some kind of hand-holding by those that are experienced, so that they can also be able to get experience. It is correct to say the numbers that are growing are juniors, and some of them, they have been licensed, but without any projects for a number of period. So that is something that is critical, and also something which is important. It's for also the mother department to review the legislation in terms of what is and then a business rescue practitioner, because in terms of the act, is the person that is been appointed, not a person that is helping. So those are the also challenges that we are having, that they are of a a problem that we cannot just recognize the experience against what the law says, but we need then to review the law so that it also covers for those that are licensed. However, they might not be appointed, but they are working together with the senior practitioner so that those experiences are covered as well. Thanks.
Okay, I think we're gonna leave it there. I just want Gideon maybe to have the last word on just this aspect, and that is the role of education, especially for junior practitioners. What are your thoughts, being a young blood? I'm not so sure if you're under 40 still, Gideon.
Yes, I am still. Thank you, Eric. Although my grey beard doesn't tell that story. So I think the only answer to that question is that you pick up your phone or you take your phone and you phone Renee Becker and you actually enlist in the SARIPA Mentorship Programme. I think it's been running for 3 years, if I'm correct. And, it's a fantastic opportunity to actually be deployed to a senior. And I think one of the success stories that I'm aware of is actually Farello, who's sitting on this platform, who participated, I think it was 3 years ago, in this mentorship program, and he is currently consulting and assisting, the post office business rescue team. So that just shows of what success can come out of the SARIPA mentorship program. Thank you.
Excellent. Okay, guys, we're going to leave it there. I must just say it's been a really refreshing and interactive discussion today. I mean, there are lots of other role holders, or role players rather, and stakeholders which we haven't debated today. For example, Competition Tribunal, the DMR, trade unions all have an active role to play in pushing business rescue to where it should be. So I want to thank all of you, Gideon, Joe, Ian, Harry, and Vianney. And I must say, Vianney, I really find your approach and Sipsi's approach incredibly refreshing and positive and incredibly proactive. So I must personally thank you, and I'm sure SARIPA agrees with me that Sipsi are really moving this narrative forward for business rescue and for all the business rescue practitioners on today's session. So thanks again to all the panelists. Thanks to Angela, Connie, and George Nell for organizing today's SARIPA webinar. I wish everybody a happy Easter and a good break over this weekend. And I wish you a good afternoon. And again, thank you to my panel and for the preparation time and your contributions. Thanks so much.
Thank you
so much.
Cool.
Thank you.
Thank you.
Bye.
Thank you very much. Bye-bye.